W in another.
Good morning, Mr. Sultan.
Good morning, Madam Chief Justice, and may it please the Court. The legal issues that are embodied in the questions reported by the juvenile court in this case are really quite straightforward. First, does Lowell's juvenile curfew ordinance infringe upon fundamental constitutional rights?
Who has the burden of proof here?
Well, the appellants below filed a motion to dismiss. So to the extent that the report has occurred on their motion, I have no problem assuming the burden of proving.
I mean, who has the burden of proof initially? It would be you, wouldn't it?
Right.
I have no problem accepting the burden of proving that the ordinance is unconstitutional, Your Honor.
Okay, and what level of facts would you say is required of a legislative body for it to act?
Well,
It's not the type of facts we require in a judicial proceeding.
well, Your Honor, no, it's not. But when we get to the whether this court ultimately decides that strict scrutiny applies or intermediate scrutiny applies under either of those tests, and I submit because fundamental rights are infringed by this ordinance, that one of those two standards, those are the only two possible standards, under either one, it is the burden, in fact, on the, in this case, the Lowell City Council, to demonstrate, in the case of strict scrutiny, that the ordinance is narrowly tailored to a compelling state interest and utilizes the least restrictive means necessary, or under intermediate scrutiny, that the ordinance is substantially related to an important governmental interest. So it is their burden, it is my burden to prove it's unconstitutional. I have no problem with that, but it's their burden to establish that this infringement upon fundamental rights, in fact, is constitutionally justified under the Equal Protection Clause.
Before we get to the constitutional question, is there any statutory authorization for the enactment of an ordinance that provides for an arrest for a non-felony?
Your Honor, I am not aware of any, and frankly, that's sort of beyond the scope of the reported question. So I did not look specifically at that question. But of course, this ordinance, unlike many of the others that have been considered by courts throughout the country, does provide for criminal penalties and does provide for an arrest and loss of liberty.
What are the criminal penalties?
Well, Your Honor, the penalty, I believe, is on the criminal side is a fine of
$300, I think?
Yes, Your Honor. That is the ultimate penalty. There's also on the civil side, there's I think a $50 fine on the civil side. But it can result in a loss of liberty because under Chapter 119, Section 52, the violation of a municipal ordinance is grounds for an adjudication of delinquency. And
Mr. Sultan, can I just, is this the only state that has criminal penalties?
No, Your Honor.
Okay.
There are a dozen or so reported decisions on this really very same issue throughout the country. Some of them have criminal penalties. Some of them have only civil penalties. There's one has a warning the first time, the first violation, simply a warning.
I didn't mean
so there's
I just
a whole
wanted to
array.
make sure. I thought I'd misheard. Please answer, Justice Ivan.
I'm sorry. Yes, Your Honor.
So could I think of this as analogous to a parent's imposition of a curfew on a child?
Well, yes, Your Honor. I think that's part of the problem, is that basically it usurps the role of the parent to, in fact, apply rules and guidance
so if
for
a parent
children.
imposed a curfew and the child didn't abide by the curfew, the parent would be, what would the parent's options be?
Well, I think I understand where Your Honor is going with this. The court, the parent could, of course, go to the juvenile court and seek services under a Chins petition.
What could the juvenile court do?
Well, obviously, under this court's decision in Florence F., the juvenile court could not lock the juvenile up, could not commit the juvenile to DYS. The court could, if it found that services were in fact appropriate, could provide services. So this essentially, this ordinance, among its many infirmities, allows for the kind of bootstrapping that this court specifically recognized in Florence F. is a potential problem. These two kids, these two 16-year-olds in this particular case, they were arrested. They were arrested basically for doing nothing more than essentially walking down the street. They were arrested. They were held overnight. They were brought to the station the next day in custody. I mean, they went through that loss of liberty, and they certainly could have been adjudicated delinquent. They could have been placed on probation for this offense, and they ultimately could have been committed to DYS because of a violation of probation, exactly the problem that this court perceived and responded to in Florence F. That is one of the many infirmities of this statute and one of the ways in which it can infringe upon fundamental rights.
I'm sorry, they could not have been committed to DYS for violating the curfew statute, or did I misunderstand?
Well, actually, no. Your Honor, under Chapter 119, Section 58, they could.
Even though it says that the penalty is a $300 fine?
Well, because under Chapter 119, Section 52, the violation of a municipal ordinance is grounds to adjudicate a juvenile delinquent. Once they're adjudicated delinquent, under Section 58, it is up to the court to decide what's the right remedy, and one of those options is commitment to DYS.
But back to the question I was asking you, if we thought of this as a curfew violation, it's a Chin's case, and Chin's cases by definition are non-criminal.
Well, that's right, Your Honor, and I think it is in some ways. This is basically criminalizing what is a status offense, which is exactly what we in Massachusetts and nationally, what the legal system has been trying to get away from since In re Galt was decided 40 years ago. This essentially is an end run around that important legal principle in juvenile cases, which this court has assiduously maintained.
Well, let me ask you this. What could a community do that was beset with violence committed by juveniles and in an effort to try to reduce the violence, try to keep young people off the street? What could a community do? Is there anything?
Well, I suppose if the community could show, if they could meet their very heavy burden under strict scrutiny, which we say is what they have to meet, to show that, in fact, that 90% of juvenile crimes are occurring between 1 a.m. and 4 a.m.
Or 11 a.m. and 5 a.m.
I mean, whatever. I mean, if they can somehow establish, make the showing, perhaps some kind of a curfew, perhaps with civil penalties, not criminal penalties. Perhaps it's possible. It's really, I mean, it's up to them to decide what to do. They can't do this.
I get back to the question I asked you before, and you didn't answer it.
I'm sorry, Your Honor.
What level of facts is required for the legislative body to act? Suppose the question that Justice Island posed.
Well,
what type of facts? It's not what we require in court.
Well, Your Honor, I think you have to look at some of these cases. For example, an intermediate scrutiny case, which is, I think, lower scrutiny than what applies here, Craig versus Boren, which was a Supreme Court case where there was a distinction.
It doesn't have anything to do with the level of scrutiny we apply. That's how you answered it the last time. What type, regardless of what their burden is, whatever standard they have to meet, what type of facts do they put in? Do they put in an affidavit from the police commissioner that it's bad here?
No, Your Honor, they did that. They have to show objectively analytical. They have to present objectively analytical proof that there is a fit. That there is a fit between this extremely burdensome restriction, which basically locks everybody under 17 in their house 25% of the time. They have to show there's a close fit, a close fit between that and what they're trying to accomplish. They can do it with statistics. They have to do it with real proof. They can't do it with an affidavit from the police chief saying, gee, if we keep everybody off the street, crime's going to go down. That's not good enough.
We permit our legislature, and this is the equivalent, we never require that type of proof of them when they enact statutes.
We do, Your Honor, if they impinge upon fundamental constitutional rights. That both this Court and the Supreme Court have said where fundamental constitutional rights are impinged upon, they have to show that it's narrowly tailored. They have to show that.
One of the questions is whether the juvenile has a fundamental right to be at large between 11 p.m. and 6 a.m.
Well, that's not how I would define it, Your
That's
Honor.
right. I know you don't define it that way.
Because I would define it as I mean, in more than 50 years ago, this Court said in Carpenter that mere loitering or sauntering on a public way is the right of every man, woman, and child. The U.S. Supreme Court said in Papa Cristo more than 40 years ago, they extolled the right of people to walk around, to stroll.
We don't let juveniles go into a lot of things. A lot of them. We just don't.
Well,
Under 17 can't go in. Sometimes it's can't drink, for example. Can't go into a bar.
Those are not fundamental constitutional rights, Your Honor. The right to move around, the right to walk down the street without being stopped by the police, interrogated, having to show papers, those are fundamental rights. They're fundamental rights under, I would say, substantive due process. The right to go to participate in or attend First Amendment protected activities, sporting events, plays.
But society also has a right to protect its children.
It does, Your Honor.
And that may mean infringing on what you might say is a fundamental right.
It does.
If an adult exercised it.
Well, of course, society, and we've acknowledged here, there is a compelling interest in protecting children.
All right, and there's a compelling interest, for example, maybe not, but certainly a strong interest in having them go to school, 7 a.m. to 3 p.m.
And those statutes have been upheld,
Absolutely.
compulsory education statutes. That's
so
right.
it's not in our interest to make sure that they're awake when they go to school. I mean, there are a number of reasons why, presumably, this curfew makes sense. One of which is it keeps juveniles off the street at this particular time period, when apparently there's some historical evidence that violent crimes are committed during this time period. People get in trouble during this time period. Juveniles have obviously less experience, less sense, etc. But it also ensures that maybe they're possibly home, sleeping.
Well, Your Honor, number one, it viscerally makes sense. But, I mean, that's exactly what the U.S. Supreme Court has said. That's not the basis for evaluating. We can't use stereotypes. We can't use anecdotes. We have to
We can use reason and common sense.
Well, reason and common sense, Your Honor, would say that if people are forced to stay in their homes, they cannot be, whether they're adults or minors, they are not going to be on the streets committing crimes. But in a free society, that is not a limitation that the Constitution permits. The Constitution also allows parents to make these decisions for children. If a parent wants to let a child, a 16-year-old, go to a Celtics game in Boston and come back on the train, or go to a play, or go to a concert, or go out with his or her friends to a local coffee house, or go over to a friend's house to do homework together and come back at 11:30 or 11:45, that is up to the parent. That is not up to the state. Those are the kinds of rights that are infringed by this ordinance.
Is that a violation of the Lowell curfew if you got your parents' permission to be abroad? I couldn't remember whether some
It is, Your Honor. Your parents' permission is not an exception. You have to be there are these exceptions that are written in there, but simply having your parents' permission, having a note from your parent saying Johnny is going to the symphony tonight and in Boston, and he may be home after 11, so that when the person is confronted on the street coming over from the train station and said, let me see your papers, what are you doing here, they pull out that piece of paper. Even that's not good enough under the Lowell Ordinance, Your Honor.
Mr. Sultan, may I?
Are you challenging, it seemed from your brief, you're not, and obviously in this context I'm not sure you could, you're not challenging the civil piece of this, is that right?
Your Honor, we are challenging, that's right, we're challenging what happened to my clients. But I think that to the extent the Court wants to look at the ordinance the ordinance as it reads now is facially invalid. It infringes upon fundamental constitutional rights in myriad ways. It's subject to strict scrutiny, and because the city has not come close to demonstrating that this is narrowly tailored to its objectives, it fails. It fails not only for that reason, it fails because minors can be locked up under this ordinance. It fails because it vests far too much discretion in the police. Basically, under this ordinance, the police it's left to them to decide whether or not to arrest somebody or not arrest someone based on whether they reasonably believe that a violation has occurred. That is obviously a lower standard than probable cause, and that's unconstitutional.
But what you're hearing is a question as to whether the issue is the fact that it's criminal or the issue that it is illegal. We right now require kids' right to travel to be limited, that they're supposed to be in school between 8 and 2. One can say that's a breach of their fundamental right to travel. We don't make it a crime. We give the truant officer the arrest power to bring the kid back to school, not to arrest him. Should the police have any less power between 11 p.m. and 5 a.m. than what a truant officer has between 8 a.m. and 2 p.m.?
Well, it may well be that there's some interest that's comparable to the interest in education, which this court, the Supreme Court, has found justifies compulsory education, which would justify such a curfew. I don't believe so. I think that it would still run afoul because there's still no fit. They still have to show that this curfew reduces juvenile crime, and they admit in their own brief that they can't prove it.
Not for a civil one. I mean, one of the justifications, couldn't it be for a civil one, sort of following up on Justice Cordy, if you're worried about the juveniles, to use the Bellotti v. Baird, the second of those categories, can't make decisions for himself. So the juvenile shouldn't be out at 2 in the morning because indeed the statistics show that's when, forget juvenile crime, that's when an awful lot of violent crime may happen. And so we don't want them to be, not in terms of we don't want them to commit it, but we don't want them to be in a situation where they could get hurt, they could make bad judgments, and so we're going to have a civil curfew.
Well, Your Honor, I submit you are still infringing on their rights without an adequate showing under the level of scrutiny that has to be applied. I mean, there is an analytical framework that has to be applied here. It shouldn't be me or this court, obviously, substituting its judgment as to whether or not that's reasonable.
But that's not one you could, that one, statistics aren't going to help. What we're saying is it is in the nature of being under 17 that you can't make those kinds of judgments. I don't know exactly how, if you accept that as a proposition, how is a city or town ever going to be able to show that?
But, Your Honor, I mean, in Bellotti v. Baird, the Supreme Court said in striking down the parental consent for abortion statute that was not, you couldn't make that kind of sweeping generalization. And I don't think you can make it here either.
Mr. Sultan, could I ask you this question? I was struck, this ordinance was enacted in 1994, correct?
Yes, Your Honor.
In the Second Circuit decision, which also looked at an ordinance similar to this, it was also 1994 that seems to be remarkably similar to this ordinance. I mean, was there something going on in 1994 that these ordinances were, I mean, it seemed remarkably similar.
Your Honor, if you look at a number of these decisions are remarkably similar. It seems like there was a trend, I would say, in the 80s, I guess, and going into the 90s to enact these ordinances. But if the court looks at Nunez from the Ninth Circuit, looks at the QUTB case from the Fifth Circuit, looks at the JP case from the Florida Supreme Court, looks at the case just last fall decided on striking down the Rochester, New York ordinance. They're all remarkably similar. Lowell copied these other ordinances. They all copy each other. So you basically you have essentially a dozen courts reviewing variations on essentially the same statute, Your Honor.
May I ask one more question? If I'm a parent and I impose a curfew on my child and my child doesn't abide by the curfew, and I contact the police and say, Johnny isn't home, it's beyond the curfew, and the police see Johnny on the street, will they take him into custody?
I would say they have a right to take him home, Your Honor, because you're the parent. That's my unschooled, because I haven't researched that specifically, but I would say you're the parent, that's your call, you have a right to ask the police to do that if you're talking about somebody of this age, but it's not the right of the state to usurp your authority and make that decision for you.
Thank you, Mr. Sultan. Good morning, Ms. Pappas.
Good morning. May it please the Court, Miriam Pappas, Assistant District Attorney for Middlesex, with Assistant District Attorney Loretta Lilios seated at the table. Massachusetts has a spectrum of regulations that intersect constitutional rights with juveniles. With respect to rights of fundamental importance, specifically the right to an abortion, we have laws restricting that right for minors. In this case, in this court in the Planned Parenthood case stated that choice by a minor is not the same as choice by an adult. We also have laws restricting a minor's ability to get married, which in the Goodrich case, this court stated was a right of fundamental importance. And with respect to regulations affecting less important or non-fundamental rights, we have laws prohibiting minors from working in certain types of employment, from purchasing firearms, restricting hours in which a minor can operate a motor vehicle. We have laws requiring children to be in school. In the case of the curfew ordinance, the question really is not whether there's a fundamental right for either adults or juveniles to interstate travel. What we're talking about here is whether or not juveniles have an unrestricted right to interstate travel. And the right involved in this case certainly cannot have as great of an impact on a juvenile's life, let's say, as the right to an abortion, yet we still have laws restricting that right in the context of juveniles.
What about your brother's argument that this criminalizes essentially non-criminal behavior?
With respect to that, I just wanted to clarify the criminal penalty portion of the ordinance. It's a fine of not to exceed $300.
With criminal consequences.
Yes,
That means that the
correct.
juvenile can be adjudicated a delinquent and subject to DYS and
Yes.
possibly incarcerated.
And I wanted to point out, reading Section 52, Chapter 119, any ordinance, whether it be civil or criminal, could potentially result in a commitment to DYS. An ordinance such as no skating in the park, no skateboarding in the park, or no trespassing in the cemetery. Reading Section 52, all it requires is a violation of a city ordinance, does not specify whether or not it's criminal or civil, could potentially result in a DYS commitment. That's up to the juvenile judge solely.
Well, how do you reconcile the Florence case then?
Your Honor, I'm not too familiar with the Florence case that was mentioned by my brother counsel.
I wrote Florence, so I'm familiar with it.
Okay.
And it was involving a student who was not complying with a judge's order to attend school. And the child was held in contempt and committed to the state. And we said, you can't do that. You can't make something that's non-criminal into something that is criminal. Isn't that exactly what's being done here?
Well, Your Honor, I mean, if that's part of the juvenile laws. I mean, we have a mandate in Section 53 that juveniles not be treated as criminals, but in children in need of guidance
Aid,
and encouragement.
and
Right.
guidance, yes.
And, Your Honor, this is an issue for a specially appointed judge, juvenile judge, to make a decision whether or not to commit a juvenile to DYS based on previous
Well,
criminal...
this is a curfew violation.
Yes, it is.
So it's really a chance matter, isn't it? A status offense case as opposed to a delinquency case?
Well, it's a delinquency issue in the sense that a juvenile could be adjudicated technically as a delinquent based on violation of this ordinance.
But staying out too late.
Yes.
But the concern, I think, is that if there were to be an ordinance declaring every child in Lowell to be a child in need of supervision, and if a curfew were to be imposed under the Chins law, a violation of that curfew could not result in a finding of delinquency. But here, a violation of curfew can result in a finding of delinquency.
Your Honor, there are 9 exceptions that apply to violation of this curfew ordinance. This is not a blanket restriction on a juvenile's right to interstate travel.
But they're pretty specific. I mean, you can't, to take Mr. Sultan's example, would you disagree that if my child, age 16, is going to do homework with somebody else, and that's just an arrangement they've made, and I'm fine with that, and he's coming home at 1 in the morning because it's a huge project, he could get arrested for that, right?
Yes. Under that circumstance, it has to be on an errand at the direction of a parent. So even if a child is not supervised with an actual...
So my point is just that the exceptions hardly make this non-burdensome and very restrictive on the juvenile.
Sorry, make this...
They hardly take away the burden and the restriction that this curfew imposes on them and their families.
I don't believe it's overly restrictive at all. I think the 9 exemptions are pretty clear. There's one for First Amendment rights. There's one for interstate travel. And I think it goes along the lines of other curfew ordinances.
Ms. Pappas,
If
sorry, finish your answer.
if anything, there are many more exemptions that apply to this curfew ordinance than others.
Ms. Pappas, there seems to be an agreement, at least of the cited authorities, that for juvenile crime there's a peak immediately after school hours in the early part of the afternoon. You would agree?
I would agree with that, and what I can say is that...
Let me just ask my
Okay.
question. My question is, if the city of Lowell, in order to address juvenile crime, enacted an ordinance that said all juveniles have to be off the streets immediately after school in the afternoon from 3 p.m. until 8 p.m., is the analysis any different?
I think the analysis would be different given that there are non-exemptions that apply, and if
What do you mean there are non-exemptions that
Well-
applied? Assuming that the exemptions applied, your
Yes.
parents and so on and so forth.
Well, I think it would be impractical to try to limit a juvenile's mobility during after-school hours, given all the extracurricular activities that
Well, let's
they're likely
assume that the
involved in.
city decides that they can handle this. They can handle this. They really want to go after juvenile crime. So I'm not asking you as a policy maker. I'm simply saying, do we review it in the same way? It essentially goes to Justice Cowan's point.
And Your Honor, it's a little hard for me to answer that question because one of the exemptions is attending an official school, religious
This
or
is
other
after school.
recreational activity.
This is do you know what time the city of Lowell public schools release their children?
I am not certain.
Would you say 1:30 in the afternoon?
Possibly 2:30.
Would you say 3 o'clock? You don't know, but let's assume this is
Yes.
after school. So the city says a lot of crime on the streets, and in fact there's lots of evidence of that. So what we want to do is make sure there are no kids on the streets from 3 to 8. We're not too worried about the 1 o'clock in the morning because in fact the juvenile crime rate drops precipitously early in the early hours of the morning. A lot of juvenile crime in the afternoon. Is the analysis different?
The analysis would be the same, but there, like I said, I mean, I keep on mentioning this exemption that is in the current curfew ordinance for attending after school activities. So, you know, if a juvenile was involved in after-school activities, a club or something, under the current statute, even if the hours
Lots
were
of
not...
children don't attend after-school. Lots of children don't attend after-school programs, and we can almost take judicial notice of the fact that because of the budget crisis, almost all after-school programs in major cities are being cut.
I mean, potentially, Lowell could enact such a curfew ordinance. However, the goals of the ordinance, I mean, the goals of the city in enacting this ordinance were prevention of crime, protection of juveniles from each other and other persons during nocturnal hours, and promoting family responsibility and parental supervision. So I'm not so sure those goals would apply to an ordinance that affected after school hours when presumably many parents would be engaged in employment and things of that nature. So I just don't see the two ordinances for those
Now, I understand that
time periods
there may be a difference with respect to the third factor. I was looking at the two first factors on which the city has relied.
Are there standards guiding the police as to when they may arrest or when they must arrest?
It's certainly an issue of police discretion, but under the enforcement section,
Well, might this be an improper delegation then, if there's
I
no
don't-
standards?
I don't believe so. I think in many situations, police have discretion whether or not to issue a criminal complaint or arrest or not do anything at all. I don't think this is any different. And certainly with respect to the 9 exemptions, I think they're pretty clear. I don't think there's a lot of ambiguity involved in, you know, an officer obviously would know what the curfew was, the hours that it applies, as well as the 9 exemptions. So I don't see that
There's
as
a lot of
being a
courts
problem.
that find ambiguity in the First Amendment exercise, aren't there?
And other courts, such as Ramos, have stated that citizens of that particular town, ordinary citizens, are expected to know what the protections of the First Amendment are.
Now, Ramos did not uphold a remarkably similar. Ramos did not uphold a remarkably similar ordinance, correct?
For different reasons, though, Your Honor.
No, I understand that.
There wasn't the same sort of nexus. Maybe the basic, you know, the time frame for the curfew were similar, but you know, it was a different, certainly a different situation. And also the case of, sorry, also in the case of Hutchins, the court stated that really in that case, the First Amendment exception was nearly exactly the same as the Lowell's ordinance exception, and there the court said that that the exception was no more vague than the First Amendment itself.
The plurality. The
Sorry?
plurality of that court?
I believe so, yes, in the Hutchins case.
Justice Spina asked whether there's any problem about having what is clearly not a felony be an arrestable offense. Can you shed any light on that?
Well, I think it's the criminal, even you know, given what I said, that even a violation of a civil ordinance could potentially result in DUI's commitment. I think, you know, giving the police discretion to arrest a minor, I think that could maybe lead to good things. Maybe not. I mean, I think right now.
Pappas, with all due respect, it's not what you think. It's not what you think.
Okay.
It could lead to good things. The question is, what's the basis for saying a non-felony is an arrestable offense?
In the context of juveniles, it could potentially result in improving a juvenile's life in
I mean,
arrest.
it may be that in the juvenile, I just don't know this. In the context of juveniles, there isn't a prohibition against arresting for something that's non-felony. I just didn't know if you knew anything about that.
No, Your Honor, I'm sorry. I think my brother counsel said the same thing, but that issue wasn't briefed. I'm not familiar with that.
May I ask you this? Assuming this resulted in a delinquency commitment to the Department of Youth Services, that's until the child reaches the age of 18. So we have a curfew violation, they have a trial, they're found to have violated the curfew, and they're committed to DYS. They could be locked up, placed in the custody of DYS until they're 18 for staying out beyond the curfew.
Yes, potentially, yes.
This may not be relevant. I'm just curious. This ordinance was in effect since 1994.
Yes.
These juveniles were arrested in 2004. Have the police been enforcing this ordinance since 94?
I believe
And this is the first challenge.
it's my understanding that it started being enforced, went into effect really, it was past 1994, went into effect 1995. So yes, this is the first time, you know, our office has come across such a case.
Do you know, does the record establish whether there have in fact been prior arrests under the ordinance?
It's a lengthy report, I thought,
Yeah,
about
there
prior
is-
arrests in the
right, there's
in the
some.
appendix.
There is.
So the answer is yes, I think.
Yes. Yes. I mean, there's several reports. The dates on them are post-2000 for the most part.
1999 to 2004 curfew report, for
Yes.
example, from
Yes.
the police department. Yeah.
Did the curfew show whether the child was arrested and held overnight?
Sorry.
Do the reports show whether the child was arrested and held overnight?
The actual police reports? No. But my brother counsel has stated that, based on what he said, that they were in fact held overnight.
Well, we know that
Not on the face of the police report.
we know that the two juveniles in this case were held overnight.
Right, right. If there are no further questions, I'll rest on my brief.
Thank you, Ms.
Thank
Pappas.
you.
We'll take a short break.